here again to discover some provisions of the new civil code. The provisions that we will discover tonight is about the new civil code article 9, which states that no judge or court shall decline to render judgment by reason of silence, obscurity, and insufficiency of the laws. Article 9 of the Civil Code is applicable to criminal prosecution. The judge may not decline to render judgment. Instead, the judge must dismiss the criminal action, applying the rule of nolum crimen, nolla pone sine lege. Means, there is no crime when there is no law punishing it. The judge may dismiss the case if somebody is accused of non-existent crime. So what must the judge do? If the law is silent and obscure and insufficient, the judge may use under the old civil code when there is no statute. If the law is silent or is obscure or insufficient with respect to particular controversy, the judge shall apply the custom of the place, and in default thereof, a general principle of law and justice. In the case of SILVERIO versus Republic, GR number 174689, October 22, 2007. The facts of the case. On November 26, 2002, petitioner Romel Jacinto Dante Silverio filed a petition for the change of his first name and sex in his birth certificate in the Regional Trial Court of Manila. Petitioner alleged in his petition that he was born in the city of Manila to the spouses Celesio Pitine Silverio and Anita Aquino Dantes on April 4, 1962. His name was registered as Romel Jacinto Dante Silverio in his certificate of live birth. His sex was registered as male. He further alleged that he is a male transsexual that is anatomically male but feels, thinks, and acts as a female, and that he had always identified himself with girls since childhood. Feeling trapped in a man's body, he consulted several doctors in the United States. He underwent psychological examination, hormone treatment, and breast augmentation. His attempts to transform himself to a woman culminated on January 27, 2001, when he underwent sex reassignment surgery in Bangkok, Thailand. From then on, petitioner lived as a female and was in fact engaged to be married. He then sought to have his name in his birth certificate changed from Romel Jacinto to Meli, and his sex from male to female. The petition was granted by the trial court, but the Republic of the Philippines, through the Office of the Solicitor General, filed a petition for certiorari in the Court of Appeals. It alleged that there is no law allowing the change of entries in the birth certificate by reason of sex or alteration. The Court of Appeals rendered a decision in favor of the Republic, ruled that the trial court's decision lacked legal basis. There is no law allowing the change of either the name in the certificate of birth or on the ground of sex reassignment through surgery. The issue now that went to the Supreme Court in regarding with Article 9 of the new Civil Code of the Philippines is whether or not it was correct for the court to allow the petitioner to change his name and sex in his birth certificate. The ruling of the court. No, the court is incorrect for allowing the petitioner to change his name and sex in his birth certificate. It is true that Article 9 of the Civil Code mandates that no judge or court shall decline to render judgment by reason of the silence, obscurity, insufficiency of the law. However, it is not a license for courts to engage in a judicial legislation. The duty of the courts is to apply or interpret the law, not to make or amend it. In our system of government, it is for the legislature, should it choose to do so, to determine what guidelines should govern the recognition of the effects of sex reassignment. The need for legislative guidelines become particularly important in this case, where the claims asserted are statute-based. If the legislature intends to confer a person who has undergone a sex reassignment the privilege to change his name and sex to conform with his reassignment with sex, it has to enact legislation laying down the guidelines governing the conferment of the privilege. It might be theoretically possible for this court to write a protocol on when a person may be recognized as having successfully changed his sex. However, this court has no authority to fashion a law on that matter, or in anything else, the court cannot enact a law where no law exists. It can only apply or interpret the written word of its co-equal branch of government. Congress, however, it is not a license for courts to engage in judicial legislation. The duty of the court is to apply or interpret the law, not to make or amend it, because such would be actually an amendment of the law. Petitioner's basis in praying for the change of his first name was his sex reassignment. He intended to make his first name compatible with the sex he thought he transformed himself into through surgery. But there is no law allows the changing of name and sex on the basis of sex reassignment. The Supreme Court now affirms the decision of the Court of Appeals and reversed the decision of the Regional Trial Court in Manila. Thank you, and I hope that you learned and discover Article 9 of the new Civil Code.
Singing